Nonini, Nuxel, Patrick, Pierce, Rice, Schmidt, Sidaway, Stennett, Thane, Tippett, Vick, Work, Winder, Bach, Brackett, Cameron, Getty, Johnson, McKenzie, Sidaway,
Roll call shows 28 present, 7 absent or excused, a majority being present. Senate is in order. Senate will advance the second order of business, prayer and pledge of allegiance. Will be led in our prayer this morning by our Senate chaplain, Jim Wibberding. We invite our guests in the gallery to stand and join with us in prayer and pledge of allegiance.
Let us pray. Dear God, our Maker, the first stirrings of spring waken around us, and they serve as a reminder that life and growth happen without our initiative. A million birds compose their hymns without a lecture from us. A billion flowers bloom in soil that we have not worked. A trillion spires of green rise from the earth while we sleep. At this time in the session, our good senators begin to evaluate success. And for every success, there are 3 deeds left undone. I pray that you will encourage them with the focus to finish strong, and also encourage them in the knowledge that you bless even where they have not yet touched, that flowers bloom even in unfurrowed ground. Thank you for this knowledge, and thank you for hearing this prayer today. In Jesus' name, amen.
Amen. We'll be led in the Pledge of Allegiance by our Senate page, Zach Barron.
I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Senator Getty and Senator Cameron will be recognized present at this order of business, as will Senator Sidaway. Senate will advance the third order of business, reading and correction of the journal. Senator Brackett will be recorded as present.
March 18, 2013, the Judiciary and Rules Committee reports that the Senate Journal of the Proceedings of March 15, 2013 was read and approved as corrected. Lodge Chairman.
Without objection, the report will be filed in the office of the Secretary. Senator Davis.
Mr. President, personal privilege, if I may.
Senator has the floor.
Mr. President, Senators, we have more than 120 pieces of legislation today that we need to consider in some fashion in the various orders of business. Of course, that does include some legislation we are not likely to get to today. It is our intent to go through the various orders of business in the order that they lie. We will be going into the 10th order of business, so if you have those concurrent resolutions, if you'd be prepared and ready to go, as I'm sure you are, then that will help us there. In the event, however, there is a problem with any legislation either in the 10th order or in the 13th order of business, if you'd let us know, I would appreciate it. Mr. President, I ask unanimous consent to send advance to the 5th order of business.
Before advancing the 5th order of business, Senator Bach will be recognized present at this order of business. Without objection, the Senate will advance to the 5th order of business, petitions, resolutions, and memorials. Senator Davis.
Mr. President, I ask unanimous consent that all petitions, resolutions, and memorials be read by number, author, and title only, and the journal show they've been read at length.
Without objection, is so ordered.
In the Senate, Senate Concurrent Resolution number 127 by State Affairs Committee, a concurrent resolution stating findings of the legislature and authorizing the Legislative Council to appoint a committee to monitor energy, environment, and technology issues, and to monitor the Integrated State Energy Plan and other issues.
Senate Concurrent Resolution 127 will be referred to the Judiciary and Rules Committee for printing. Senator Johnson will be recorded present at this order of business.
There is no further business in the fifth order, Mr. President.
Senate will advance to the sixth order of business, reports of standing committees.
March 18, 2013, the Judiciary and Rules Committee reports that Senate Bill 1179 has been correctly printed. Lodge Chairman.
Senate Bill 1179 will be referred to the Transportation Committee.
March 18, 2013, the Judiciary and Rules Committee reports that Senate Bill 1050, 1081, 1083, 1058, 1014, and Senate Bill 1032 have been correctly enrolled. Lodge Chairman.
Senate Bills 1050, 1081, 1083, 1058, 1014, and 1032 have been signed by the President and will be transmitted to the House of Representatives for the signature of the Speaker.
March 15, 2013, the Judiciary and Rules Committee reports that enrolled Senate Bill 1055, 1113, 1007, 1008, 1024, 1092, 1120, 1043, and Senate Bill 1089 were delivered to the Office of the Governor at 2:15 p.m. March 15, 2013. Lodge Chairman.
Report will be filed in the Office of the Secretary. Senator McKenzie is recognized as present, as is Senator Johnson.
March 15, 2013, the State Affairs Committee reports out House Bill 192, 223, Senate Bill 1126, and Senate Bill 1127 and recommend that they do pass. McKenzie, Chairman.
House Bill 192, House Bill 223, Senate Bill 1126, Senate Bill 1127 will be referred to the 12th order of business, second reading calendar.
March 15, 2013, the Finance Committee reports out House Bill 283, 284, 285, Senate Bills 1167, 1168, 1169, 1170, 1171, 1172, 1173, 1174, Senate Bill 1175, 1176, 1177, and Senate Bill 1178, and recommend that they do pass. Cameron, Chairman.
House Bill 283, House Bill 284, and House Bill 285, Senate Bills 1167, 1168, 1169, 1170, 1171, 1172, 1173, 1174, 1175, 1176, 1177, and 1178 will be referred to the 12th order of business, second reading calendar.
Mr. President.
Senator Cameron.
Thank you, Mr. President. For a unanimous consent request.
Senator has the floor.
Mr. President, you just read Senate Bill 1175. We should have placed on everyone's desk a corrected fiscal impact statement. We found an error in the original fiscal impact statement, and so staff has prepared a new one. With that, Mr. President, I would ask unanimous consent that the new fiscal impact statement be included with Senate Bill 1175.
For the unanimous consent request, is there objection? Hearing none, it is so ordered.
March 18, 2013, the Judiciary and Rules Committee reports out Senate Bill 1109 with the recommendation that it be referred to the 14th Order of Business for amendment. Lodge, Chairman.
There being no objection, Senate Bill 1109 will be referred to the 14th Order of Business for possible amendment.
March 18, 2013, the Judiciary and Rules Committee reports out House Bill 147, 148, and House Bill 149 and recommend that they do pass. Lodge, Chairman.
House Bills 147, 148, and 149 will be referred to the 12th Order of Business, second reading calendar.
March 18, 2013, the State Affairs Committee reports out House Bill 121, 183, and House Bill 193 as amended and recommend that they do pass. McKenzie, Chairman.
House Bill 121, 183, and 193 as amended will be referred to the 12th Order of Business, second reading calendar.
There is no further business in the sixth order, Mr. President.
Senator Davis.
Mr. President, I ask unanimous consent to send advance to the 9th order of business.
Hearing no objection, the Senate will advance the 9th Order of Business. Messages from the House.
March 15, 2013. Mr. President, I transmit herewith House Bill 256, 293, and House Bill 258, which have passed the House. Alexander, Chief Clerk.
House Bill 256, House Bill 293, and House Bill 258 will be referred to the 11th Order of Business for introduction.
March 15, 2013. Mr. President, I return herewith Senate Bill 1025, 1057 as amended, 1091 as amended, 1098, 1048 as amended, 1034, 1035, 1128, 1129, 1130, 1131, 1132, 1139, 1140, 1143, and Senate Bill 1144, which have passed the House. Alexander, Chief Clerk.
Senate Bills 1025, 1057 as amended, 1091 as amended, 1098, 1048 as amended, 1034, 1035, 1128, 1129, 1130, 1131, 1132, 1139, 1140, 1143, and 1144 will be referred to the Judiciary and Rules Committee for enrolling.
March 15, 2013. Mr. President, I transmit herewith enrolled House Bill 26, 44, 46, 118, 117, 188, 211, 140, 107, 161, 181, House Joint Memorial 1, House Bills 55, 251, 253, 255, and House Bill 177 as amended in the Senate for the signature of the President. Alexander, Chief Clerk.
House Bill 26, House Bill 44, House Bill 46, House Bill 118, House Bills 117, 188, 211, 140, 107, 161, and 181, House Joint Memorial Number 1, and House Bills 55, 251, 253, 255, and House Bill 177 as amended in the Senate have been signed by the President and will be returned to the House of Representatives.
Mr. President.
Senator Davis.
Mr. President, I ask unanimous consent to advance to the 10th order of business.
Hearing no objection, the Senate will advance to the 10th order of business, motions and resolutions. The Senate now has before it for final consideration Senate Concurrent Resolution number 125. Secretary will read the resolution.
In the Senate, Senate Concurrent Resolution number 125 by State Affairs Committee. A concurrent resolution stating legislative findings and approving administrative rules that impose a fee or charge with stated exceptions.
Mr. President.
McKenzie.
Mr. President, I ask unanimous consent that we dispense with further reading of Senate Concurrent Resolution 125, but our journals show that we did read it at length and that it's now before the Senate for consideration.
Hearing no objection, so ordered. Senator McKenzie.
Mr. President, I move the adoption of SCR 125.
Second the motion.
You've heard the motion and the second that the Senate adopt Senate Concurrent Resolution 125. Senator McKenzie is recognized to open debate on the motion.
Thank you, Mr. President and Senators. You may have heard of a going home bills that we've got to address before we leave. This and the next one are two of those. If we don't adopt these, government, as we know it in the state of Idaho, would cease to exist. Or, at the very least, it would present a minor inconvenience for our agencies. What these do, this SCR 125 is the concurrent resolution that approves fees or charges that we approved in this last session. By statute, when there is a change to a fee or a charge that any of our agencies impose on Idaho citizens or anyone else that would come under that, it's got to come before the legislature for approval. Those have gone to all the committees. The committees have analyzed those. They've approved some. They've rejected some. And what this concurrent resolution does is reflect the action of those committees. So for all the fees or charges that were approved by the legislature, this is the concurrent resolution that approves those so that they can be approved by the agency. And it lists the ones that the committees did not approve. There was, I think, a rule from the Department of Agriculture related to organic food product rules, a rule docket from the State Athletic Commission related to the State Athletics Commission charges, and then I think a rule docket from the Lottery Commission were the ones that the committees had rejected, and then we'd accepted the rest. Mr. President, with that, debate is open.
Debate being open. Is there further debate? Hearing none, Senator McKenzie is recognized. Close debate.
The debate's closed.
Debate being closed, the question is, shall the Senate adopt Senate Concurrent Resolution number 125? All in favor say aye. Aye. Opposed nay. Ayes have it, and the concurrent resolution has been adopted. Is there correction to the title? Hearing none, title is approved, and Senate Concurrent Resolution number 125 will be transmitted to the House. Senate now has before it for final consideration Senate Concurrent Resolution number 126. Secretary will read the resolution.
In the Senate, Senate Concurrent Resolution number 126 by State Affairs Committee. A concurrent resolution stating legislative findings and approving and extending temporary rules reviewed by the legislature.
Mr. President.
Senator McKenzie.
I ask unanimous consent that we dispense with further reading of SCR 126, but our journal show we read it at length.
Hearing no objection is so ordered. Senator McKenzie.
Mr. President, I move the adoption of SCR 126.
Mr. President, I second the motion.
You've heard the motion and the second. Senator McKenzie is recognized to open debate on the motion.
Thank you, Mr. President. This is one of my favorite pieces of legislation that we act on every year. This is sometimes called the drop-dead bill. This is the resolution that continues temporary rules and other rules of our agencies. I get to carry this for several sessions, and it's always my chance to point out how we do it different than our federal government does. I don't know of any legislative body that has such control over agency rules and the rulemaking process as the Idaho legislature. In contrast, our federal government passes broad, sweeping legislation and leaves it to unelected agencies to impose all the contents of those, and we see that in just about every area. But one of the prime examples is in the EPA regulations and rules that are as significant as any statutes in the country, but there's not the same accountability to elected officials as if they'd passed it by statute rather than letting the agencies do it by rule. So what this does, it's fairly short. The statement of purpose you can see there, but temporary rules expire at the end of the year. So this approves and extends those rules, and then there's an additional section that says temporary rules or sections of temporary rules, which in addition to those that had not been submitted for review during the last session, expire by operation of statute on adjournment of the session unless we approve them. So it just applies that same standard to all of them. And so we will continue to review those closely and make sure that the rules that Idaho citizens come under are consistent with the statutes that we pass and for which we are accountable to the voters. Mr. President, with that, debate's open.
Debate being open, is there further debate?
Mr. President, I ask unanimous consent, Sanquades.
Without objection, the Senate will be at ease. The Senate will come to order. Before going at ease, the Senate was in the 10th order of business and had under consideration Senate Concurrent Resolution number 126. Senator McKenzie had been recognized to close debate on the resolution.
Thank you, Mr. President. Debate is closed.
Debate being closed, the question is, shall Senate Concurrent Resolution number 126 be adopted by the Senate? All in favor say aye. Aye. Opposed, nay. Ayes have it, and Senate Concurrent Resolution number 126 has been adopted. Is there correction to the title? Hearing none, title is approved, and Senate Concurrent Resolution 126 will be transmitted to the House of Representatives.
Unanimous consent, send advance to the 11th order of business.
Hearing no objection, the Senate will advance to the 11th order of business, introduction and first reading of bills. Senator Davis.
I ask unanimous consent that all bills on first reading be read by number, author, and title only, and the journal show they've been read at length.
Hearing no objection, is so ordered.
In the Senate, Senate Bill number 1180 by Finance Committee, an act appropriating monies to the State Board of Education and the Board of Regents of the University of Idaho for special programs for fiscal year 2014. In the Senate, Senate Bill number 1181 by Finance Committee, an act relating to appropriations, distributions, and transfers of the Idaho Millennium Funds, appropriating monies to the Department of Correction for the Community-Based Substance Abuse Treatment Services program for fiscal year 2014. In the Senate, Senate Bill number 1182 by Finance Committee, an act appropriating additional monies to the Department of Correction for fiscal year 2013. In the Senate, Senate Bill number 1183 by Finance Committee, an act appropriating monies to the State Board of Education and the Board of Regents of the University of Idaho for health education programs for fiscal year 2014.
Senate Bills 1180, 1181, 1182, and 1183 will be referred to the Judiciary and Rules Committee for printing.
In the House of Representatives, House Bill Number 256 by State Affairs Committee, an act relating to the Child Protective Act, to revise requirements relating to a certain petition and to make technical corrections, to provide that upon entering a certain decree, the court shall place the child under the protective supervision of the Department of Health and Welfare, and to revise provisions relating to certain written findings required of the court. In the House of Representatives, House Bill Number 293 by Appropriations Committee, an act appropriating monies to the Department of Health and Welfare for the divisions of mental health services, psychiatric hospitalization, and substance abuse treatment and prevention for fiscal year 2014. In the House of Representatives, House Bill Number 258 by State Affairs Committee, an act relating to licenses to carry concealed weapons, to require the sheriff to provide the applicant with a copy of the results of the applicant's records check upon request of the applicant under certain conditions.
House Bill 256 will be referred to the Judiciary and Rules Committee. House Bill 293 will be referred to the Finance Committee, and House Bill 258 will be referred to the State Affairs Committee.
There is no further business in the 11th order, Mr. President.
Senate will advance to the 12th order of business, second reading calendar.
Mr. President.
Senator Winder.
Thank you, Mr. President. I ask unanimous consent that all bills on the second reading be read by number and author only, and journal show they've been read at length.
Hearing no objection, is so ordered.
In the House of Representatives, House Bill Number 216 by State Affairs Committee. In the House of Representatives, House Bill Number 76 by Business Committee. In the House of Representatives, House Bill Number 127 by Business Committee. In the House of Representatives, House Bill Number 162 by Education Committee. In the House of Representatives, House Bill Number 185 by Environment, Energy, and Technology Committee. In the Senate, Senate Bill Number 1135 by Judiciary and Rules Committee. In the House of Representatives, House Bill Number 218 by Education Committee. In the House of Representatives, House Bill Number 225 by Education Committee. In the Senate, Senate Bill Number 1146 by State Affairs Committee. In the House of Representatives, House Bill Number 110 by Agricultural Affairs Committee. In the House of Representatives, House Bill Number 113 as amended by Agricultural Affairs Committee. In the Senate, Senate Bill Number 1047 as amended by Local Government and Taxation Committee. In the Senate, Senate Bill Number 1134 as amended by State Affairs Committee. In the House of Representatives, House Bill Number 73 as amended in the Senate by State Affairs Committee. In the House of Representatives, House Bill Number 217 as amended in the Senate by State Affairs Committee.
House Bills 216, 76, 127, 162, and 185. Senate Bill 1135, House Bill 218, 225, Senate Bill 1146, House Bill 110, and House Bill 113 as amended, Senate Bill 1047 as amended, Senate Bill 1134 as amended, and House Bill 73 as amended in the Senate, and House Bill 217 as amended in the Senate will be referred to the 13th order of business, third reading calendar.
There is no further business in the 12th order, Mr. President.
Senate will advance to the 13th order of business, third reading of bills. The Senate had under consideration Senate Bill 1114 as amended. Debate has already been opened. Is there further debate on 1114 as amended? Hearing none, Senator Lakey is recognized to close debate on the bill.
Thank you, Mr. President. Again, just a reminder, Senators, this is a good bill that's the result of 10 years of effort and some individual visits and discussions in the various regions around the state. This bill consolidates the substance abuse and the mental health system into a single consolidated behavioral health system, and then gives those local regional boards that are established the control and the authority to determine how support services are provided at the local level. Senators, this is a good bill and does help make those support services more effective when they're provided at the local level. And with that, Mr. President, debate is closed.
Debate being closed, the question is, shall Senate Bill 1114 as amended pass the Senate? Secretary will call the roll.
Bear. Bayer. Bach. Brackett. Buckner-Webb. Cameron. Davis. Durst.
Mr. President.
Senator Durst, for what reason do you rise?
Mr. President, to explain my vote.
Senator has 60 seconds.
Thank you, Mr. President. I was hoping that the handouts that would be distributed right now would have been distributed earlier, but they weren't. So just a real quick explanation. I think that this legislation, while good intentioned, is lacking significantly in the ability to provide for preventative care, which is really the bugaboo of our mental health system in Idaho. That NAMI and other groups that are associated with mental health and advocacy for mental health have come out against this legislation, and I'll be voting no.
Senator Durst votes no.
Fulcher. Getty. Guthrie. Hagedorn. Hyder. Hill.
Aye.
Johnson. Keogh. Lacey. Lakey. Lodge.
Senator Lodge.
Mr. President, having had the opportunity to work a little bit on this legislation throughout this 10-year period of time, I would like us to recognize former Senator Stegner for the work he did to bring this all together and bringing all the parties so that they had input into this legislation. It's been a long time coming and is needed in this state, and I will be voting aye. Thank you, Mr. President.
Senator Lodge votes aye.
Martin. Aye. McKenzie. Mortimer. Nonini. Nuxall.
Mr. President,
Senator Nuxall.
if I may, 60 seconds to explain my vote.
Senator has 1 minute.
I am very grateful to the senator from District 12 who worked very hard at this and made some great changes in the bill, and it's really improved. However, I still have a problem with the definition of behavioral health, and I'm afraid that sometime I might be included in that. So, thank you.
The senator votes
Nay.
Senator Nuxall votes nay.
Patrick. Pierce. Rice. Schmidt. Sitaway. Stennett.
Mr. President, to explain my vote.
Senator Stennett has 60 seconds.
Thank you. I greatly appreciate all the work that's been done on this. We have so much further to go along with mental illness and services. I unfortunately am a little disturbed by the language that it codifies something that we've done post 2008 when we did take, or 2010 when we took a lot of the revenues out of certain departments to help with mental illness and the services, and I think this just codifies a practice that I was hoping that we would improve upon, and so I reluctantly will have to vote no.
Senator Stennett votes no.
Thane. Aye. Tippett. Fick. Work. Winder. Bach. Davis. Getty. Johnson. Keogh. Rice. Schmidt. Work.
Roll call shows 25 aye, 10 nay. A majority having voted in the affirmative, Senate Bill 1114 as amended has passed the Senate. Is there correction to the title? Hearing none, title is approved, and Senate Bill 1114 as amended in the Senate will be transmitted to the House of Representatives. Senator Davis.
Mr. President, I ask unanimous consent that House Bill 199 hold its place on the calendar. May I explain?
Senator has the floor.
Thank you, Mr. President. Good senators, the floor sponsor for that legislation is not currently available to present the bill. In the event that we are able to find the time later, we may circle around and pick it back up.
Hearing no objection is so ordered. Senate now has before it for final consideration House Bill 41. Secretary will read the bill.
In the House of Representatives, House Bill Number 41 by Health and Welfare Committee, an act relating to driver's licenses to clarify when visually impaired individuals are considered
Mr. President.
Senator Johnson.
Thank you, Mr. President. Mr. President, I ask unanimous consent that further reading of House Bill 41 be dispensed with, and the journal show that it has been read the third time at length, section by section, and placed before the Senate for final consideration.
Hearing no objection, is so ordered. Senator Johnson is recognized to open debate on the bill.
Thank you, Mr. President. Senators, this bill, House Bill 41, deals with what are called bioptic drivers. And bioptic drivers are individuals who have a visual impairment that can be corrected through lenses or these bioptic glasses that these individuals wear to operate a vehicle on our state highways. Currently, what the law says is that if you have a visual impairment that cannot be corrected to at least 20/40 in one eye, you're considered incompetent to operate a vehicle in the state of Idaho. If it's more than that, and you can get an ophthalmologist, which is a medical doctor, or a licensed physician, to sign off that your visual acuity, the clearness of your vision, can be corrected to at least 20/40 on the Snellen test or some other test, then you can be considered competent. So in other words, that restriction can be removed, and you can then get a driver's license to operate a vehicle. What this bill does is it removes a presumptive clause in the language which says that if you receive a tax benefit or some other benefit because you are considered legally blind, which is vision of 20/200 or worse, that you are conclusively presumed incompetent to operate a vehicle. And so this language would remove that clause and state that you can still operate a vehicle with a driver's license if a certified physician or ophthalmologist, and in this case an optometrist, signs off and says that your acuity can be corrected so that you can see well enough to operate a vehicle, and then you have to pass a skills test. So we've had bioptic drivers in the state of Idaho for about 20 years, and the state of Idaho does not have any records on these individuals, whether or not their crash rates are higher or if there's fatalities caused by these drivers. There's no records on that. Bioptic drivers have been around since the early 1970s, beginning in California. And Mr. President, if I can just read from a few emails that I've received on this issue, just for background information for the body.
Having identified the source, Senator may read.
Thank you, Mr. President. This is from a gentleman who is a bioptic driver, and he writes, "As a young man, I was on disability because of my vision, but this was not an avenue in my life that I wanted to have. My quality of life was limited, and I did not like getting a free ride and free money. I pursued a profession, and I have achieved it. If this bill is not passed, there's good possibility that I will be forced to return to this lifestyle. It may mean losing my home and current lifestyle because of limited income. Most important is that my independence will be stifled. I will be limited to when and where I can go, and will have to rely upon others to help me perform simple daily tasks. This is not the life that I want to live." And also from another constituent, he writes, "This bill concerns individuals who are using visual devices to get to and from work. In your district, you may have an individual who requires a special device to get to and from work. Assistive technology enables a number of people in our state to engage in work. These devices range from hand controls in vehicles to canes for walking. Through the Vocational Rehabilitation Program, individuals with disabilities are allowed to gain and or maintain their employment by obtaining assistive technology devices. House Bill 41 will enable persons with visual disabilities to maintain their employment." And then lastly, Mr. President, this is from a certified skill test drivers in Idaho. He says, "I've been a contracted Idaho skills tester for over 10 years. I administer over 1,000 driving exams each year. Over the past decade, I've been able to test thousands of teen drivers, adults, and drivers who have special accommodations due to physical disabilities who desire to drive on our public roads. I have tested hundreds of drivers with vision limitations as requested by the drivers themselves, family members, private optometrists, or by the State Department of Transportation. Many of those with limited vision have used bioptic lenses in order to see and drive safely. In 10 years of testing, I have yet to fail a bioptics testee. They are responsible citizens and are aware of their visual limitations without their bioptic lenses. Good Senators, this bill has been before the Senate in previous years, and it's back before us today. The request is to remove that presumptive clause upon the signature recommendation of a licensed optometrist, or physician that would allow these individuals to keep their driver's license to maintain their independence. Currently, if that is not removed, these individuals are subject to losing their driver's license. With that, Mr. President, debate is open.
Debate being open, is there further debate? Senator Work.
Mr. Chairman, will the good senator stand for a question, please?
Senator from District 6, would you yield to a question?
I will, Mr. President.
Senator from District 17 to state your question.
Thank you, Mr. President. Thank you, Senator from 6. I just wanted to clarify, I assume that the people in this class that we're dealing with in this bill are, they comply with the requirements and receive some kind of a tax benefit as being blind or visually impaired. Is that correct?
Senator from 6.
Mr. President, thank you, Mr. President, and good Senator from 17. That was the origination of the bill. That's correct, Senator. The Tax Commission, I guess, flagged this because applicants were receiving tax benefits for having a disability, and then they were also applying for and receiving a driver's license to operate a vehicle. And under the current law, you can't have both. You have to have one or the other.
Thank you, Mr. President. Thank you, Senator.
Is there further debate? Hearing none, Senator Johnson is recognized to close debate.
Thank you, Mr. President. Debate is closed.
Debate being closed, the question is, shall House Bill 41 pass the Senate? Secretary will call the roll.
Baer. Bayer. Bach. Brackett. Buckner-Webb. Cameron. Davis. Durst. Fulcher. Getty. Guthrie. Hagedorn. Hyder. Hill.
Aye.
Johnson. Keogh. Lacey. Lakey. Lodge. Martin. McKenzie. Mortimer. Nonini. Nuxel. Patrick. Pierce. Rice. Schmidt. Sidaway. Stennett. Thane. Tippett. Fick. Work. Winder. Davis. Work.
Roll call shows 34 aye, 1 nay. A majority having voted in the affirmative, House Bill 41 has passed the Senate. Is there correction to the title? Hearing none, title is approved. House Bill 41 will be returned to the House of Representatives. Senate now has before it for final consideration House Bill 170. Secretary will read the bill.
In the House of Representatives, House Bill number 170 by Transportation and Defense Committee, an act relating to real estate appraisers to provide that local highway jurisdictions may perform value.
Mr. President.
Senator Bach.
Mr. President, I ask unanimous consent that further reading of House Bill 170 be dispensed with, and the general show it has been read at length for the third time, section by section, and placed before the Senate for final consideration.
Hearing no objection, is so ordered. Senator Bach is recognized to open debate on the bill.
Thank you, Mr. President, fellow senators. This is an interesting bill because it is, if passed, it's going to save local highway districts some money. Right now, under the Real Estate Appraisers Act, there is a requirement that essentially a full appraisal be done with respect to parcels of property that are worth less than $10,000 and are subject to the eminent domain process. The problem with requiring a full-blown appraisal with these properties is that the appraisal itself can cost $2,000 or $3,000. And if you can imagine that you have a piece of property worth $5,000 and you're going to get an appraisal that's going to cost you $2,000 or $3,000, it quickly becomes cost ineffective, I should say. At any rate, right now, the ITD has an exception to this requirement, so it can use a value appraisal for properties worth less than $10,000. It can use essentially an internally certified state appraiser to make this evaluation rather than do a full-blown appraisal. This bill would extend that same right or authority to local highway districts. It's a way in which we can make the process more efficient and more cost-effective, and I urge that you vote yes on this bill.
Debate being open, is there further debate? Hearing none, Senator Box recognized closed debate.
Thank you. Debate is closed.
Debate being closed, the question is, shall House Bill 170 pass the Senate? Secretary will call the roll.
Bear. Bayer. Bach. Brackett. Buckner-Webb. Cameron. Davis. Durst. Fulcher. Getty. Guthrie. Hagedorn. Hyder. Hill.
Aye.
Johnson. Keogh. Lacey. Lakey. Lodge. Martin. McKenzie. Mortimer. Nonini. Nuxel. Patrick. Pierce. Rice. Schmidt. Sidaway. Stennett. Thane. Tippett. Fick. Work. Winder.
Roll call shows 35 aye, no nay. A majority having voted in the affirmative, House Bill 170 has passed the Senate. Is there correction to the title? Hearing none, title is approved, and House Bill 170 will be returned to the House of Representatives. The Senate now has before it for final consideration House Bill 214. Secretary will read the bill.
In the House of Representatives, House Bill Number 214 by Health and Welfare Committee, an act relating to putative fathers, to provide a code reference and to revise provisions relating...
Mr. President.
Senator Davis.
Mr. President, I ask unanimous consent that further reading of the bill be dispensed with and the Journal show has been read at length the third time and placed before the Senate for final consideration.
Hearing no objection, is so ordered. Senator Davis is recognized to open debate.
Mr. President, Senators, this is not a bill that was just assigned to me, and as a result, I'm doing my duty to the Asinore. This is a bill that I care about. Every senator on this floor values life. Every senator that I have served with seeks public policy that protects our children, especially our newborn children. It is my experience that adoptions help to protect certain newborn children. And in my opinion, this bill strengthens Idaho's adoptions laws. Let me explain. Recently, the Utah Supreme Court and one Utah District Court set aside 3 different adoptions because 1 of birth mother's misconduct and 2 statutory needed modifications. Idaho's putative father statutes are mirrored in part after Utah's, and as a result, there is concern. Also, Idaho had a couple of bungled adoptions that illustrate the need for statutory improvements. Can you imagine the concern to, and in turn, the choice of the biological mother that considers adoption if there is uncertainty in the adoption process, including the termination of parental rights? Can you imagine her concern and her possible choice if an adoption fails and her consent to the adoption is used against her in a custody battle with the biological father? Can you imagine the concern of, and in turn the choice of, adopting parents to participate in adoptions if there is uncertainty in the adoption process and an infant child that they want to love, they want to nurture, may be taken from their family? Can you imagine the adopting parents and families' heartache if an adoption is undone? But most important, the question that we should wrestle with, in my opinion, is what is in the best interest of this infant child. We seek to avoid attachment disorders or reactive attachment disorders from adoptions or disrupted adoptions. We desire that newly placed children have a stable and safe family life. And we desire that adopting parents be able to love the child and to behave for them as if they have always been part of the family. I know we all hope for certain and stable adoptions. Adoptions do need to be stable, and this bill increases that likelihood. Over the past several sessions, various statutory modifications were introduced and were stalled. Promises were made to engage, including by me. And last summer, a group was formed. It included several adoption lawyers. It included Rob Luce with the Department of Health and Welfare. He is an attorney, but currently serves as an administrator with the Division of Family and Community Services. Additionally, Senator Lodge, who was then the chairman of the Health and Welfare Committee, was involved. And then they let me be part of the process. When we got out of our area of expertise, we sought and obtained additional legal input from bench and bar. We drafted and we redrafted. We initially introduced a bill, Senate Bill 1015. Further modification was needed, and so a new bill was introduced, the bill you have. If you want to know why it became a House bill, you can ask me, but it's a little embarrassing to me personally, so please don't now, unless you're really curious. If you want to understand the framework, the public policy that the state of Idaho uses to determine and balance the competing interests, my apologies, of the various players or interested parties in an adoption, you will not find it in this bill. This bill is a modification of the current statutes. But if you will pull out Idaho Code 16-1501, capital A, this is my printed off and marked up copy, you will see how we as a Senate previously wrestled with the balancing that has to occur between the compelling interest of the state, the unmarried mother, and by the way, this bill applies to biological unmarried fathers. It talks about the rights of the adoptive children, the adoptive parents, And then it speaks about the inchoate interest in the unmarried biological father. And then what this does is it talks about the importance of having finality in adoptions. And then finally, in subparagraph 4, it walks through the specific finding of the legislature as to the rights of privacy to the mother and the need to have a stable adoption. If you have questions about this bill, I'd start here with 1501A and look at it because it substantially modifies and qualifies the other provisions that are in the bill. In the event that the biological father is married to the birth mother, there are additional notices and consents that are required in order for that child to be put up for adoption. This bill does 7 things. This is my breakdown of the bill. The first thing it does is it provides parallel statutory language throughout. If you look at the paternity determination section, you look at the termination of parental rights code section, and the adoption statutes, they use terms that mean the same thing, but occasionally have chosen historically different words. What this bill does is it trues up those terms so that what you will read in those code sections are more similar than currently dissimilar. The second thing it does is it creates a date certain for putative fathers to act, and I'll come back to that one and these other points in a moment. Second, it creates one exception to that date certain standard that is oftentimes referred to as the impossibility exception, not because it's impossible, it deals with misconduct. It directs the Department of Health and Welfare to produce a pamphlet and host on the web a public service announcement regarding the putative father's rights. It incorporates the current best interest of children standard that exists in divorce proceedings into the paternity statutes. It creates one exception to that best interest factor. And finally, it adds a brief reference to the Indian Child Welfare Act, which you may hear me refer to as ICWA. Putative. What does the word putative mean? That's not a word that I think we use a lot in our common speech. Putative means to be reputed, to be believed or supposed. So a putative father is the alleged biological father of a child born out of wedlock. That's from Black's Law Dictionary. The Putative Father Registry is a confidential registry hosted by the Department of Health and Welfare Vital Statistics Bureau, where a putative father can commence proceedings to establish paternity. First, it's actually the second of the 7 modifications, but the first one was just truing up language. But in the area of substantive ones, what this bill does is establish a date certain for a putative father to act. What it does, if you'll look on page 1, lines 36 to 37, is it adds the words the before standard with either before or after the birth of the child. And so that commencement of the proceeding can begin before or after. 2, it modifies and ties in modifications to 16-1504-9, where the putative father must file proceedings prior to the date of the filing of the petition to terminate the birth mother's parental rights. A failure by the putative father to participate in that by either registering on the putative father registry or otherwise judicially engaging would cut off their right to assert a right to parent the child. There is, however, you will note on page 5 of the bill, lines 6 through 44, what is referred to as the impossibility exception. And what it does is it provides for an exception where the biological father has failed to act for, quote, no fault of his own. In other words, fraud by the birth mother. We have, in the instances referred to before, the biological father was not just aware of the pregnancy, but had been led to believe that he would have some active role in parenting the child. Promises were made, action was taken. In one of the cases out of Utah, the pregnancy occurred in, I don't know where it actually occurred, but she was living in the state of Colorado immediately prior to birth, moved to Utah, sought to terminate the parental rights, and he was caught flat-footed. Under those circumstances, this statute would allow for the putative father to be granted an additional 10 days after the birth of the child. Now, different states have handled the impossibility standard differently. Some have put the putative father on a clock that is by the hour, 72 hours. Some states have granted up to 30 days. We have chosen, and I am recommending, that you consider 10 days. The putative father would have to demonstrate in court by clear and convincing evidence that it was not possible for him to file a proceeding prior to the petition to terminate the birth mother's parental rights, again, through no fault of his own. The next area in the bill, of course, is on page 9, and I apologize, I'm skipping around a bit, and you'll notice in the bill that there are tweaks throughout that try to incorporate all of these modifications. The pamphlet and web page is on page 10, lines 70 to 50, and then also at the top of the following page. It does have to be done within the limits of continuing annual appropriations, and the purpose is to teach about the putative father registry, the procedures, and also the effect. The next area that the bill deals with is really on the top of page 2 in the bill, where you'll see that there is a new section created, 7-1126, section 2 of the bill. This section does two things. It codifies what I believe is an appropriate judicial standard of using the best interest of the child standard into custody proceedings as part of a paternity action. Our Idaho Supreme Court has already imputed that standard to those proceedings. All this does is take advantage of that language, but it provides an additional exception. You'll notice on line 6 of the bill, the conjunctive adverb, however. This one exception says that if there is a consent to an adoption, that consent, in the event that the adoption fails, cannot be used as a factor to determine what is in the best interest of the child. The policy reason behind that, I think, is mostly obvious, and that is that if you are a birth mother and you are contemplating whether to give that child up for adoption, one of the considerations and concerns that a birth mother will have is, does the consent itself, could it come back to hurt her in the event that the adoption fails? What we want is the birth mother to have confidence that consenting to the adoption will not hurt what she believes is in the best interest of that child. The final principal portion of the bill is the addition of the Indian Child Welfare Act, just the reference to it. It is as this floor knows, and those who have served with me in different committees, I am not a fan of referencing or codifying federal standards in the Idaho Code. I understand the doctrine of preemption. You do too. I don't think it is necessary for us to reference ICWA in the Idaho Code. However, what was suggested to us by our friends in tribes was that we do this. Instead, what you have is this reference that, if applicable, nothing in this chapter shall modify the requirements of, and then it goes on to say ICWA and the code section. Why would we do that? Why would I ultimately think it's appropriate to do it and request your consideration? There is a case called the Baby Veronica case in which we had a child placed for adoption. There was non-compliance with ICWA, and as a result of that, it undid that adoption downstream. Most lawyers that practice in the area of adoption are skilled and capable, and they know the questions to ask, and they do not need to have a passing reference to this federal statute. There are, however, lawyers like me that occasionally dabble in it. Not so much today, but perhaps in yesteryear. What we want those practitioners to do as they look at the code is to stumble onto that code section and be reminded of it first, or alternatively, if this is news to them, spend a little time to make sure that they have complied with it, so that in the event you have an Indian child or a child that has the requisite percent of tribal membership, that they be able to be protected under this federal statute. And that is the reason that you see the language there. This bill is, in my opinion, intended to add clarification. This does not structurally change the prior policy of this state on putative fathers and putative father registry. It adds some consistency throughout the bill. In my opinion, it will strengthen the adoptions here in Idaho, and it reduces the chance that a court will unwind an adoption. Mr. President, Senators, debate is open.
Debate being open, is there further debate? Senator Bach.
Yes, Mr. President, debate in favor of the bill.
Senator has the floor.
Yes, Mr. President, good senators, is the good senator from District 33 is well aware. I've asked some very pointed questions about the bill and the rapidity with which the father can lose his rights under this bill. But a couple of points are very important. I think they're consistent with the good senator's debate, and one is that this actually affords the putative father with even more protection than he has now. And so I think it's a step in the right direction. And then the good senator alluded to the necessity of balancing the interests of the child versus the interest of the father. And I think this balancing comes down about right. The thing that we need to be absolutely certain about, I think, is that we don't see a lot of adoptions going bad. We do need to watch out for the best interest of the child. And I think this bill appropriately balances the various rights, and I urge your vote in favor of the bill.
Is there further debate? Senator Durst.
Mr. President, to debate against the bill.
Senator has the floor.
Thank you, Mr. President. I'm going to try to keep this as short as I can and try not to get emotional, but this is an issue that I know a little something about, having been on the other side of the equation from that of the sponsor. I first want to say I appreciate the efforts that have been made by the Senator from 33 and others on this issue. I think that it's been a good faith effort to try to address this issue. But I believe that we've fallen short of the standard that we should expect for our fathers. As a little background, I think I'm probably the only one in this chamber that's ever been a biological dad out of wedlock. I think I'm pretty certain that that's true. And so I've got to experience the Idaho legal system in all its glory and how it treats unwed fathers when a child is born. I can tell you firsthand it doesn't treat us very well. In fact, we have to take exceptional steps to even begin to get any access to our child. Even the most interested of fathers has to do things that you would never expect anyone to expect. You would never expect any wedded father to do to be able to see their child. In 2004, I was presented, after making some poor choices, I was presented with the opportunity to have a child. I had already accepted a fellowship for graduate school in California, and I'd left and found out later that I was going to be having a child here in Boise. There were a lot of ranges of emotions that I went through at that time. Fear, anxiety, excitement. I knew from day one that I wanted to be a part of my son's life. The problem was that because I was in the state of Idaho, or the child was going to be born in the state of Idaho, I had very little rights as a father in an unwedded situation. The reality is that in almost all those circumstances, the deck was stacked firmly against me. I remember taking classes, parenting classes, when I was in grad school while I was waiting for the birth of my son and to finish the semester in California. And the dads there were talking about how they immediately had joint 50-50 custody with their child, how all they had to do was just sign a little piece of paper and it was done. I explained to them in Idaho what I had to do was hire an attorney, put an attorney on retainer, and pray to God that the judge that happened to be up for our case was sensitive to the issues of fathers. That's another issue here. There is no consistency in family law with regard to application of law when it comes to unwedded fathers. In fact, there are many judges throughout the state that are frankly hostile to unwedded fathers. They take the view that the father made the mistake and that they're going to have to pay for it. It seems to me that fathers have just as many rights, or at least they should. When the Creator created the union between a man and a woman to create a child, He didn't say which one should have superiority over the other. But in our current Idaho law, and in this bill in particular, we're seeking to expand the inferiority of a father in that relationship. What this legislation does, and what other legislation like this has done, is it allows the mother to make the decision for the father. It's not uncommon, and in fact it almost happened to me, for a mother who's expecting to hide herself from the father. You can go into a hospital and go into that hospital and not be registered with the hospital so that you can't be seen on the patient registry, thereby hiding your existence and the birth of your child from any potential outside observer. Well, the idea of 10 days seems generous. If as a father you're expecting your child to be born on November 1st, because that's the due date, and the mother chooses to go into labor on October 20th and not put her name on the registry and refuse to answer your phone call, under this statute, you've lost your right. I think the rights of a parent are compelling, and they are one of the most profound rights that we as a society can protect. The rights of a father are already on level, as I've already been saying. I experienced the same thing. My son was supposed to be born in late November, or in the second week of November. mother decided to go into labor, and luckily she had a relationship with some other members of my family, so I kind of knew what was going on after the fact. And I flew in and I had to do an immediate injunction on the case. I had to, luckily I had parental support to be able to put $5,000 down for retainer. Not everyone's so lucky. There are many people in this country in this state that wouldn't have that family support the way that I do. And while there wasn't an attempt to adopt in that particular case, my parental rights could have been terminated. The senator from 33 talked about the best interest of the child. I am convinced that having a father and a mother, whether or not they're wed or unwed, as a part of that child's life is in the best interest of that child. I am convinced that a biological father knows best of what his child more than any adoptive parent could. And that's not to just say adoptive parents don't do a great job. As a pro-life legislator, I push for adoption in those cases. But if a father shows an inkling to support that child, he should be given any and every opportunity to do so. With regard to the impossibility clause that the senator from 33 talked about, I can tell you that it comes down to the judge's discretion. If that judge is feeling welcoming to that father's rights, then yes, it may work. But I can tell you I have had, and I have seen experiences when I was going through my own situation where my attorney told me, we better pray to goodness that we don't get that judge, because if we do, your day's over. You will never see your child. Why, as we as a state, would we want to create a public policy where we disadvantage fathers in such a negative way? I understand that a mother has the need to make a decision for her child. But just like if we were going to have an abortion, we should still have some input from the father before it happens. The father has a right. The Lord made it so we had two to create a child. The two should both be responsible for deciding when that rights of those parental rights have been terminated and an adoption goes through. With that, I'll be voting no.
Is there further debate? Hearing none, Senator Davis recognized closed debate.
Mr. President, I'm sorry. May I direct a question to the senator from 33, please?
Senator Davis, would you yield?
I will yield.
Thank you, Mr. President. Good senator. Not being aware of the judicial proceedings associated with adoptions, is the putative father provided with notice that there is a potential adoption that might occur prior to, the adoption proceeding itself, or prior to some period of time?
Senator from 33. To respond to the senator from 17.
Thank you, Mr. President. Senator from 17. I prefer the old days when we used to have little cards. I could see them a little bit better, but I have this, and supposedly it's easy to use, but some days I make it hard to use. As I heard the senator from 18's passionate opposition to the bill, I have to admit my heart went out to him. I have to admit I have not been in his position, and I certainly seek for a public policy that is as sensitive to all of the various challenges that we wrestle with. I certainly seek for a judiciary that is filled with men and women that are going to make good decisions. But if you look at the network of these statutes on termination, adoption, and the putative father registry, if I have a biological father, let me back up one more time. The United States Supreme Court wrestled with this very philosophy some years ago. And in that instance, the United States Supreme Court did say that the biological father brings something different than what the biological mother does. In short, what the Supreme Court said is that an unmarried biological father, by virtue of the fact that he has engaged in a sexual relationship with a woman, is deemed to be on notice that a pregnancy and an adoption proceeding regarding that child may occur. And that is the notice that they are initially entitled to. And that language has been codified in 1505, subpart 2. But additionally, it is my understanding from judicial precedent that you need to provide to the putative father an opportunity to at least assert, even from the very beginning, that in the event that a pregnancy occurs, that this biological father, whoever he may be, wants to assert and protect their rights. And so what the current statute provides is that a putative father can go online, download the putative father registry certificate that you fill out, and I read it here over the weekend, and then you can submit that for filing with the state of Idaho. Now, it's a confidential deal, so I mean, you can't get on the putative father registry online and just look at the page after page of fathers or men who may be asserting it. But in the event that a pregnancy occurs, and in the event that the birth mother wants to give the child up for adoption, that if you have placed your name on the putative father registry, then the state of Idaho and the judge, is required to receive from the Bureau of Vital Statistics a certificate that they have searched the putative father registry and you have not been found, or the biological father has not been found. And so your question was, are they required to receive notice? Well, they are certainly if they are married. If, however, the biological father is unmarried, they can protect their right by putting their name on the putative father registry. That is Idaho law today.
Thank you, Mr. President. Thank you, good Senator.
Further debate? Hearing none, Senator Davis recognized closed debate on the bill.
I was on this floor nearly, oh my goodness, how many years has it been now? 13, 14 years ago when we created the putative father registry. It was a very compelling debate. The sentiments and the concerns that you've heard from the senator from 18 were expressed then as we have heard them now. But this bill is not about that. This bill is intended instead to remove some of the remaining uncertainty that has been created based on the experiences that courts have had to wrestle with since then. I've been asked if I wouldn't mind just taking a minute on page 2 of the bill and talk about the best interest test. And so if you don't mind, I'd like to do that because my experience teaches me if one senator has this question, that others do too. In a divorce proceeding, if you, and I do not practice family law. I did for some years. I found that I just didn't have the patience to do divorce work for a long period of time. I tried a bunch of them for about 10 years, and I still remember the day that I put my assistant on notice. This is the last divorce action I was going to handle. It was a great day. It brought greater peace in my own marriage because I used to bring the anxieties from those home. But the court, in determining who is to parent the child, they look at 32717 at sequitur, and there's several sections after that. And so the court will look at a variety of factors. We've talked about them on this floor before. The wishes of the child's parent or parents, the wishes of the child as to their custodian, the interaction and relationship, adjustments that might have to be made both in home and school and community, and the list go on. What the Idaho Supreme Court and Court of Appeals have said is that if you have a paternity action, so we're not talking about terminating the parental rights, we're not talking about an adoption, and I have a man and a woman that have had a child, and there is conflict as to who is going to become the primary custodian of the child, who gets to be that custodian, the biological father or the birth mother. The code doesn't answer that because 32717 talks about it in terms of in the event of a divorce. Well, if you've not been married, there is no divorce. So the Supreme Court and Court of Appeals said 32717 at sequitur apply in the example where you have a biological father and you have a birth mother and they've not been married. So what this section does is it codifies it. But what a concern that existed by those who looked at it, and what I have heard from adoption counselors, is that when a birth mother is considering giving up the child, the fact that they have signed the consent to adoption, is that an expression that she does not want to mother the child? And the answer to that, in my experience, is nothing could be further from the truth, that she is making a decision in that moment of what she believes to be in the best interest of that child, and that is to give that child up for adoption. Perhaps the hardest decision she has ever made in her life to that point, and perhaps for the rest of her life. In the event, however, the adoption fails, what we don't want to have happen is the biological father, and I'm picking on him, though it is gender neutral in this. You don't want the fact that the birth mother was willing to give the child up for adoption to be used against her, where the exhibit is presented to the judge and the argument to the judge is, "Judge, don't give her this child. She didn't want this child. She wanted to put this child up for adoption." But that was not her intent. She did want to give the child up for adoption, but that is no longer an option for her. Now she has a different set of choices to make. The termination is not going to occur. The adoption is not going to occur. We do not want to have a public policy, in my opinion, that penalizes her for having made that very difficult decision. I hope that I did a good job explaining that better. Well, adoption is important to my family. We have family members that have been adopted. I'm certain it is to you and to your family as well. We don't live in an ideal world where every putative father makes the kind of quality efforts that some have made and are to be respected for. But we are compelled to make a very difficult balancing decision, and that is the language that is in 1501A. I believed it was the right public policy some years ago. I am equally convinced today that it is the right public policy. It provides certainty in the termination of parental rights. It provides certainty in adoptions. Remember, we are focused with this legislation on what is in the best interest of that child when almost every day and week count in forming permanent and, I hope, eternal bonds. Mr. President, debate is closed.
Debate being closed, the question is, shall House Bill 214 pass the Senate? Secretary will call the roll.
Bear?
60 seconds to explain my vote.
Senator Bear?
Thank you, Mr. President. Our family is an adoptive family. I have a sister who has adopted 11 children and another sister who has adopted 5 children, and my own daughter just last summer adopted her second child. In fact, Olivia turns a year old now. I was impressed with the court system, actually, at how much opportunity and how hard they tried to identify the birth fathers of these children that have been adopted. And I think that the court system is doing a good job. The senator votes aye.
Senator Bear votes aye.
Bayer? Bach? Brackett? Buckner-Webb? Cameron? Davis? Durst? Fulcher? Getty?
Mr. President.
Senator Getty.
Not having debated the bill, may I have 60 seconds?
Senator has 60 seconds.
Thank you, Mr. President. I would like to laud the senator from 33 and his work on this. This particular issue came to my attention a couple of years ago with a constituent that had a problem, and while this does not satisfy all her concerns, it goes a long ways. The senator votes aye.
Senator Getty votes aye.
Guthrie? Hagedorn? Hyder? Hill?
Aye.
Johnson? Keogh? Lacey? Lakey? Lodge? Martin? McKenzie? Mortimer? Nonini? Nuxel? Patrick? Pierce? Rice? Schmidt? Sidaway? Stennett? Thane? Tippett? Vick? Work?
Mr. President,
Senator Work, for what purpose do you stand?
to briefly explain my vote, please.
Senator has the floor.
Mr. President, I want to say that I value very much the work that has been done. I value the debate. I value the answer to the question, and I'll certainly will support the bill. It feels to me, as I support, that there should be some kind of affirmative obligation on the birth mother to somehow notify. But that's a debate for another time, and I will be supporting the bill, so I do vote aye.
Senator Work votes aye.
Winder? Stennett?
Roll call shows 34 aye, 1 nay. A majority having voted in the affirmative, House Bill 214 has passed the Senate. Is there correction to the title? Hearing none, title is approved. House Bill 214 will be returned to the House of Representatives. The Senate now has before it for final consideration House Bill 224. Secretary will read the bill.
In the House of Representatives, House Bill Number 224 by Education Committee, an act relating to education, to establish provisions governing certain contracts, declaring an emergency and providing a sunset date.
Mr.
Be it-
President.
Senator Thane.
Thank you, Mr. President. I ask unanimous consent that further reading of House Bill 224 be dispensed with, and the journal read that show that it's been read at length for the third time, section by section, properly placed before the Senate for final consideration.
Hearing no objection is so ordered. Senator Thane is recognized to open debate on the bill.
Thank you, Mr. President. And Senators, this is one of the bills necessary because of the fallout of the defeat of Proposition 1, which is a labor negotiations bill. This actually is in hope to avoid some potential lawsuits. There's an Attorney General opinion asked by the Department of Education concerning which set of labor laws should be in place this school year in dealing with labor contracts. And so this bill states that the contracts that were in force when the school year started, when they're entered into, are the contracts that will be in force until the end of this school year. The specific impact is it clarifies when a teacher evaluation should be performed. It also has an impact on, currently there's contract A and B contracts, and some of those teachers are in their 4th and 5th year, and it answers that question if they have automatic tenure or not. The feeling is by the Department of Education and many administrators is that before you get to your tenure, you go through that fairly rigorous evaluation process. And without this bill, there's a high likelihood that the 4th and 5th year teachers will get tenure without having that rigorous evaluation process. There is a sunset clause in this bill of July 1st, 2015. There might be some question about that. That has to do more with administrators. Some administrators often have 3-year contracts, and so their contracts could extend until July 1st, 2015. It won't affect teacher contracts. Their contracts will be redone at the end of this school year. And with that, Mr. President, open debate.
Debate being open, is there further debate? Hearing none, Senator Thane is recognized to close debate.
Debate is closed.
Debate being closed, the question is, shall House Bill 224 pass the Senate? Senator Winder.
Thank you, Mr. President.
Secretary will call the roll.
Bayer. Bach. Brackett. Buckner-Webb. Cameron. Davis. Durst. Fulcher. Getty. Guthrie. Hagedorn. Hyder. Hill.
Aye.
Johnson. Keogh. Lacey. Lakey. Lodge. Martin. McKenzie. Mortimer. Nonini. Nuxel. Patrick. Pierce. Rice. Schmidt. Sidaway. Stennett. Thane. Tippett. Fick. Work. Winder. Bach. Buckner-Webb. Martin.
Roll call shows 34 aye, 1 nay. A majority having voted in the affirmative, House Bill 224 has passed the Senate. Is there correction to the title? Hearing none, title is approved, and House Bill 224 will be returned to the House of Representatives. The Senate now has before it for final consideration House Bill 220. Secretary will read the bill.
In the House of Representatives, House Bill Number 220 by State Affairs Committee, an act relating to horse racing. By the
Mr. President.
Senator Lodge.
Thank you, Mr. President. I ask unanimous consent that further reading of House Bill 220 be dispensed with, and the Journal show it has been read for the third time at length, section by section, and placed before the Senate for final consideration.
Hearing no objection, is so ordered. Senator Lodge is recognized to open debate on the bill.
Thank you very much, Mr. President. I feel like one of those racehorses that's just ready for the big race in anticipation of this bill. Senators, today I bring to you for your consideration and support House Bill 220, Historical Horse Racing. Support of this legislation will ensure long-term sustainability of the horse race breeding, training, and racing, the entire equine industry in Idaho, and the significant economic benefit that this industry contributes to this state. It will also support an increased funding for the Public School Fund, county fairs, 4-H, FFA, and the equine industry in Idaho. Idaho is reported to have the highest rate of horses per capita in the United States. There are about 210,000 horses in Idaho. The equine industry amounts to a $1.2 billion economic impact in Idaho and involves citizens of all ages and all statuses. Farmers, business people, laborers, and even teachers are owners and trainers of racehorses. There is a $1.6 billion value in the equine barns and equipment in Idaho. Idaho agriculture, agribusiness, and business commerce is interlocked with the equine industry. This would include hay and grain producers, animal health service providers, clothing and tack retailers, hospitality, restaurant, and tourism industries, just to name a few. There is hardly a business in Idaho that does not come in contact in one way or another with the equine industry or the people involved in it. House Bill 220, Historical Horse Racing, is a race involving live horses that was conducted in the past and is rebroadcast through the use of electronic technology on a delayed or replayed basis for the purpose of wagering, which is conducted at a facility that is authorized to show simulcast or televised races as stated on page 1, line 20 of the bill. A new section 542512 delineates the areas where historical horse racing can proceed. Currently, there are 3 areas in the state: Coeur d'Alene, Post Falls and Coeur d'Alene, LeBois and Boise, and Sandy Downs and Idaho Falls. This section also outlines the breakdown of the funds, which are split between various entities such as the participants, Idaho State Racing Commission, Tracks Distribution Account, Breed Distribution, the Idaho Horse Council Youth Programs, and the Public Schools Income Fund. At this time, the equine industry pays out $48 million in salaries. At the racetrack, it takes 7 to 8 people to support and care for each horse stabled at the track during a live race. The economic outlook, if this bill is passed, is the creation of 200 jobs in the first year and 500 in year 5. It strengthens the economy from $45 million to $65 million a year and ensures that Idaho horse racing is long-term in this state. Idaho has a past history of success in the horse racing business. Many of us grew up racing our horses on the weekends at small tracks around the valley. From this small beginning, LeBois was born. To some close friends of mine from Caldwell, Idaho, a baby boy was born named Gary Stevens. His father began training horses on the family Rocop farm out in Houston, Idaho. He continued training at LeBois when it opened, and Gary and his brother Scott rode the quarter horses and thoroughbreds his father trained. Gary's victories in the Kentucky Derby began in 1988 aboard Winning Colors. He also rode Thunder Gulch in 1995 and Silver Charm in 1997. Silver Charm came within a whisker of winning the Triple Crown. Gary also starred in the movie Seabiscuit and is a sports commentator who is now beginning to ride again after overcoming injuries. One of the latest successes of our Idaho racing program is a horse named Rousing Sermon. Born February of 2009 and raised from 2 months old at Treetop Farms in Parma, Idaho. He had a total winnings of $404,000 by the time he arrived at Churchill Downs in the Derby of May of 2012. He was one of the top 3-year-olds in the country, and even though he did not win, he brought fame to Idaho and his owners, Larry and Marianne Williams. Think of the odds, 37,000 foals born that had the breeding to be a Kentucky Derby champion, and Idaho had one who earned a spot in the Run for the Roses. Good Senators, this bill is another form of parimutuel betting legal in Idaho. It is a highly regulated and watched over industry. Historical horse racing helps build a purse to draw the best horses to Idaho and bring in more economic activity. Other states in the West are moving towards this form of parimutuel, including Wyoming, who passed this legislation recently. A vote in favor will maintain the viability of the Idaho horse racing industry. The list of supporters, and you have received some on your desks, for this legislation is long because of the broad impact on our economy. Good Senators, even the Horsemen's Benevolent and Protective Association supports this bill. I ask for your support for increased economic activity for Idaho business, youth programs, and the equine industry. You also have before you an Attorney General's opinion on this legislation. And just as a question I was asked just before we came on the floor, this is not one of those online internet from home where you can bet from home. You can only do this at the tracks with simulcast. And with that explanation, Mr. President, debate is open.
Debate being open, is there further debate? Senator Bach.
Yes. Would the good senator from District 11 yield to a question?
Would the senator from 11 respond to Senator Bach?
Thank you, Mr. President. Yes, I will.
Thank you, Mr. President. Thank you, good senator. I want to try to gain a better understanding as to how this process or how this works in live racing. Those who bet have to have some kind of skill at picking the horses, and I'm curious if there's the same sort of handicapping and other analysis of the races that's similar to live racing that would require some level of skill.
Senator from 11 to respond.
Thank you, Mr. President. From what I understand, good Senator, this is how it works. There's a terminal. There's 200,000 races in that terminal, and you don't know which race is going to come up. But it's been a race that has been run in the past, and so then they will give you the information about not names or places or where it is, but kind of information about the horses, and then you can choose which horse you want to wager on.
Thank you, good senator.
Thank you.
Is there further debate? Senator Lacey from 29.
Thank you, Mr. President. I'd like to support the bill in favor of the bill for my good friends in the horse racing industry. You know, horse racing is American, and there's nothing more fun than watching a sprint down the track. I was involved mid-'70s and the mid-'80s as a trainer, and have watched the difference in horse racing as the time went on. In the 70s, we had a lot of races, and you could make a little money as a trainer and also as an owner. In the 80s, when I came back and did it again, the horse races were more limited. And the reason they become limited, there's less added money. And added money is what is added to the purse to make it worthwhile to run. I know in the 80s at the end there, sometimes you didn't want to take first because by the time you paid the jockey a bonus and paid for your pictures, you had no money left. And so this has been what's been happening to the horse industry. And I think this group should be commended for their innovation in trying to bring the interest back in horse racing, to bring money back in, to have added money. When you have added money, you can put on futurities and derbies and bring horses in from Nevada, Wyoming, Washington, Oregon. All these people come in. They come in to stay in our communities. They come in and lease our facilities, and they generally bring the horses in early, so there is money spent. I think it's a great idea. It's a great sport. And, you know, as you talk about racing sometimes, especially if you talk about dog racing and that, you talk about what do you do with them afterwards. These great race horses are sent to ranches. They're sent to 4-H clubs. They're sent to rodeo, team roping, and different places like this. These horses are used after the races. They're not there to be disposed of. And I, of course, when I first saw the deal about historical races, I did ask one good friend of mine in Pocatello. I said, if you ran a race and I didn't bet right the first time, would you run it again so I could have a better chance? And of course he laughed and said, yeah, there's 200,000 of them here. Fat chance you'd ever see the second one twice. So I encourage your support. I think the great horse racing industry is a wonderful part of our life, and it's good for Idaho. And with that, I urge your support. Thank you.
Is there further debate? Senator Johnson.
Mr. President, thank you. Would the good senator from District 11 stand for a question? Yield to a question.
Senator from 11.
Thank you, Mr. President. I will.
Senator Johnson from District 6 to state your question.
Thank you, Mr. President. Good senator, on page 3, lines 20 to 23, I'm a little bit confused about the funds distribution. It talks about remaining proceeds going to the licensee, and the very next sentence says that all monies shall be continuously appropriated to the commission. So I'm trying to understand in section 6 what the difference is between the licensee and the commission.
Senator Lodge to respond.
Mr. President, good senator, the licensee is the track, and the commission is the Idaho Horse Racing Commission, which oversees all the activities of the tracks in Idaho.
Mr. Chairman.
Senator from 6.
Mr. President, thank you. Mr. President, the good senator would yield for a second.
Another question?
I will,
Senator Lodge?
Mr. President.
Senator Johnson, go ahead.
Thank you, Mr. President. So, good senator, so the sentence says that the remaining funds, which is 8%, goes to the licensee. So does that mean that the licensee keeps that 8%? Because the very next sentence says that the funds are continuously appropriated to the commission. And it seems like a conflict to me. I'm just trying to understand that.
Senator from 11.
Excuse me, Mr. President. Good senator, did you say lines 20 to 24?
20 to 23 on page 3, Mr. President.
Okay.
You're getting away from me here.
Thank
Senator
you, Mr.
Lodge
President.
to respond.
Thank you. The balance of gross daily receipts to the licensee, all monies in these accounts are hereby continuously appropriated to the commission for the further distribution and time of payment as provided in section 542513, which is this one above it, which tells you where the money's going to go. Which percentage is going to go. 1.5% of the gross daily receipts to the Idaho State Racing Commission, and then those are distributed according from line 7 through line 19. If you look at the bill, good senator, 1/2 to the Racing Commission, 1/5 of 1% to the track distribution account, 1/5 of 1%, 1/5 of 1% to the gross daily receipts to the breed distribution account, 1/2 of 1% to the public school income fund, and 1/10 of 1% of gross daily receipts to the Idaho Horse Council for youth programs. That's where the money goes.
Is there further debate?
Mr. President.
Senator Johnson.
Would the Senate be able to go to ease? Go at ease?
Without objection, the Senate will be at ease.
What you're saying, Diane, would make sense if this language here was tied in. My constituent, but it's tied in to the license, which we don't appropriate anyhow.
You know, they're out. They want to see
Or if at the end of this section, it went to sub D, and D said all of the above is continuously appropriated.
Because what it tells me is they're giving 8% to the licensee.
Senate will come to order. Before going to these, the Senate was in the 13th order of business and had under consideration House Bill 220. Debate is open. Is there further debate? Hearing none, Senator Lodge recognized closed debate on the bill.
Thank you, Mr. President. We did get our questions answered. And good senators, this is a group that came with a solution to a problem. And there's lots of competition that's going on today, but we need to do what we can to keep our equine industry viable in this state and also have the opportunity to bring some glory to Idaho through our horse racing industry. And with those comments, the debate is closed.
Debate being closed, the question is, shall House Bill 220 pass the Senate? Secretary will call the roll.
Bear. Bayer. Bach. Brackett. Buckner-Webb. Cameron. Davis. Durst.
Mr. President.
Senator Durst, for what purpose do you rise?
To provide some levity in the chamber, Mr. President, to explain my vote.
Okay.
Thank you, Mr. President.
Senator has 60 seconds.
You know, there's a lot of things I'd rather vote on than historical horse racing. For example, the fact that Boise State is in the NCAA tournament for the first time ever as an at-large bid, or the fact that Gonzaga has a #1 seed. But those bills aren't before me, so I'll be voting yes on this one instead.
Senator Durst votes aye.
Fulcher. Getty. Guthrie. Hagedorn. Hyder. Hill.
No.
Johnson. Keogh. Lacey. Lakey. Lodge. Martin. McKenzie. Mortimer. Nonini. Nuxel. Patrick. Pierce. Rice. Schmidt. Sitaway. Stennett. Thane. Tippett. Vic. Work. Winder. Bach. Martin. McKenzie.
Mr. President, to
Senator
explain my vote.
McKenzie. Senator has 60 seconds.
Senators, historic, if you look back at horse racing, 1964 was the best year in horse racing in the state of New York, which coincidentally was the year that their neighbor passed the lottery. 3 years later, New York passed the lottery. Horse racing in general across the country has been in decline since then. I think that is a significant reason why horse racing has been in decline across the country, and I know we want to do steps that we can to revive it, but I think we're just building sandcastles on the beach, and I don't think that this will be significant in the end, so I'm going to vote no. Thank you.
Senator McKenzie votes nay. Roll call shows 27 aye, 8 nay. The majority having voted in the affirmative, House Bill 220 has passed the Senate. Is there correction to the title? Hearing none, title is approved, and House Bill 220 will be returned to the House of Representatives. Senator Davis.
Mr. President, I ask unanimous consent to advance to the 15th order of business.
We'll advance to the 15th order of business, miscellaneous business and adjournment. Senator Davis.
Mr. President, Senators will soon adjourn until the hour of 9:30 a.m. tomorrow. I would remind you it is our intent to come back in and have an afternoon session tomorrow afternoon. I'll still be negotiating with our good late afternoon chairman as to when we can come in, but it is my hope we can come in at about 4 and run to 5:30. If, however, I'm told no, which I am frequently, we'll go to 4:30 and go to 6. So if we can have an hour and a half tomorrow afternoon, and then tomorrow morning for a few hours, I think we can be in pretty solid shape. Prior to adjournment, I ask if there are introductions or announcements.
Senator Lodge.
Thank you, Mr. President. Good senators, today in the gallery with us, we have several horse owners, racehorse owners throughout Idaho. And I'd especially like to recognize, they're all friends, but I'd especially like to recognize Ed and Vonze McNeilis, who I've known for many, many years, and also Larry Williams, who's the owner of Rousing Sermon. And if you could please help make all of these fine people welcome.
Senator Winder.
Thank you, Mr. President. It is our intent to go in the 14th order of business tomorrow, so if you have amendments for any of the bills that got referred over today, if you'll have them to the Secretary by 4 p.m., we'll get them on the agenda for tomorrow and take care of those for you. Thank you, Mr. President.
Senator Davis.
Mr. President, I move that the Senate adjourn till the hour of 9:30 a.m. tomorrow.
Mr. President, I second the motion.
You've heard the motion and the second that the Senate adjourn until 9:30 a.m. tomorrow. All in favor say aye. Aye. Opposed, nay. The ayes have it. The Senate will stand adjourned.
Welcome to Idaho in Session, Legislature Live, the Senate channel.